They're driving home. They get in an argument. She turns up the radio, and he says, "I'm out of here," and jumps out of the car.
While it's moving
At 35 miles an hour.
Did he die, or?
He did not die. He had a significant and serious, at age 24, lifelong brain injury.
Oh, my God.
He became a completely different person. It was like Jekyll and Hyde.
Hi, everyone, and welcome to another exciting episode of Cases Gone Wild with your host, me, Jon Marko. Thanks for tuning in. Today's episode is absolutely insane. Wait until you hear the stories and wait until you hear about our special guest. I cannot wait. This is going to be a very, very wild episode. So buckle up. If you like our show, please remember we're available on all the streaming platforms, Apple, Spotify, whatever. We also got video cameras here. We dress up nice for you, so please watch us on YouTube. You can see the video if you're able to. If you like, share with your friends, family. Let us know how we're doing. Again, Jon Marko, Cases Gone Wild. On today's episode, we are bringing in a very special, good guy, a great attorney, John Eads, who as you know, we're slightly biased here on the show. If you notice, we've only had one defense attorney on the show until now. So, John, you're the second defense attorney we've had on the show. Thanks for coming on.
Nice to see you, John, and thanks. I'll try and do as well as Tony R. did.
All right. Well, dude, you are a great defense attorney. I don't say that a lot, okay? But I had a call about a month ago, and I think I told you about this, from a mediator, a very well-respected mediator. And he said, John, he's like, I got a client or something. He's like, who are the two best defense attorneys in the state? I said, best how? He's like, the ones when you see their name on the others, on the paperwork for the court, the pleading, that you get a little upset or nervous. I said, there's only two people I can think of. One, I gave him one name, and then I said, one is John Eads. And then like a month later, we ended up having this case together, which we're going to talk about today. But, I hold you in high regards. You are a very tenacious, yet respectful, and you don't do what I call the dirty tricks. You're a straight shooter, you're a good attorney, and you're dangerous for that. So it's an honor to have you on the show. If you don't know John's currently at Gordon Reese. It's a huge defense firm. They do all kind of catastrophic claim work, trucking, environmental, high exposure cases. You're in all 50 states. You're the co-chair of the firm's trucking and transportation practice. You've been doing high exposure cases for more than 31 years. You've represented like the American League baseball teams, national sports associations. You're on the board of American Board of Trial Advocates, which is a BOTA. It's a pretty exclusive, invite only. Look, dude, you're. I'm not going to go over your resume. If you want to know about John Eads, look him up. But he's a badass. Graduated from Hillsdale in '87. Then you went to law school, University of Richmond, Virginia, right?
I did. Yeah, followed my sister, who was at William and Mary at the time, and I just love that area. But Williamsburg's a little tiny for me.
Yeah.
So the Fourth Circuit and the Supreme Court for Virginia were located in Richmond, and I just fell in love with the city. It was just big enough for me, but you could focus on just being a lawyer, serving process, having job while you were in law school. So I did that, and I worked in the library. It was just a great experience for us.
It's a good experience, and I went to D.C. for law school. And then I came back to Michigan like you did, right?
Exactly.
So
yep.
I think it's good. It gives you a perspective. It takes you out of your zone of comfort. It lets you see other places. And I think it makes us better holistic people.
No question. And some of the connections I've made just by growing up in the East Coast in Boston, relocating here, going back to the East Coast, it's kind of funny because some of the Northeastern claims adjusters like me because they hear my accent and I feel like one of them.
Yeah.
Right. And so it's great because, like you said earlier, I'm a straight shooter and I don't paint the facts. I give things a neutral balance, and I tell them, Jon Marko, fantastic lawyer. Jim Harrington, fantastic lawyer. You're going to have to pay more. And it's just a really a great way, I guess, to just make connections and earn the trust of people on both coasts.
Yeah. Sometimes having a good lawyer on the defense on a good case is a good thing because you're a straight shooter. Your experience and your reputation precedes you. So your clients listen to you. I've had some doofus lawyers on the other side who their clients don't trust or respect them. And it forces trials because nothing can get done. Look, some cases need to get tried. You're very tenacious. You will not pay on any case or not advise your client to pay on any case that shouldn't be. But on the cases that should be, you get them resolved. So you're, I think, what a good defense attorney is and should be. But okay, enough building you up and how awesome you are. Let's actually tell us some of these cases gone wild. But before we do, I found out today. So your first job was with the Kitch Law Firm here in Detroit, right?
It was, and it was a kind of a funny story to get the job because I flew out. I interviewed with Scott Salbier. I interviewed with Bill Choklos, both great men. And the night before was a long night. I was up in East Lansing at my brother's, and so we went to a couple of fraternity parties. So I came down, barely made the interview on time, and I think all of you know who Frank Tanana is. He was a pitcher his sister was Scott Salbier's secretary. And so she came out to the lobby and said, "Hey, you look like you need a cup of coffee." I said, "Oh yeah, I need a cup of coffee."
Yeah.
But
we were all a lot more fun back in the day, huh?
True to form, I did a great job at both interviews, and I really liked both Scott and Bill. But ultimately, I went to work for Scott. 2 years later, after playing hockey and playing golf and kind of getting to know the partners, they asked me to play in golf outings. So I was playing in a golf outing at Plum Hollow, and of course that's a course where I caddied as a kid. And
so you know the course well.
I know the course well.
You know the ins and outs, right?
I know the ins and outs. Kevin Muir was the pro. So in 1992, Lexus was just coming in to the United States.
And for those who don't know, Lexus is like a legal research tool. You can do all kinds of stuff on it, right? Like you can look up cases and it'll help you research statutes and laws.
Right. But the Lexus I'm talking about is the vehicle company.
Oh, okay.
So
all right.
Interestingly, they had Lexus vehicles parked in various areas of the course, including at number 2.
Hole number 2.
Hole number 2 was a par 3, 175 yards. And so interestingly, they had a bottle green coupe called I think it was a 400, some type of a coupe, and it was gorgeous. It had a
Lexus
sunroof.
Makes nice cars.
Beautiful cars. So it had a phone in it. And so I was kind of kidding with the guys, and because they were the local sales guys. Sam Serra, I think his name was from Lexus of Lakeside, and that was the only Lexus dealership in Michigan at the time. And, of course, we had Ford and GM and Chrysler, so it was a little bit still difficult to justify buying a foreign car in Detroit.
Yeah, it was taboo back in the day. Even when I first started, It was like, if you got to have a big 3 car. If the jury sees you rolling around in, like a Japanese car or something, it could be trouble.
Not good, especially working for a defense firm, very conservative. We're representing doctors.
Right.
So anyway, this particular vehicle was parked right next to the hole. I was joking around with the guys, talking on the phone, and sure enough, I step up and
So was this vehicle was it a prize or?
It was we didn't really know. It was parked there, and so you didn't know if it was a lease situation or if you won like a cash prize. It really wasn't well publicized. All we did know was that the fundraising event was Lexus Champions for Charity.
Yeah.
So,
and if you got a hole-in-one, you got something?
Something. You didn't know what it was.
And so you're golfing.
I'm golfing with 3 other people, right? 2 carts, 4 people. And it just so happened that the CEO of St. John Hospital is in the foursome right in front of us. So I step up. I think we had played 4 or 5 holes, so I was getting a little warmed up. But it was a cold September morning. And
how long had you been a lawyer at this time?
2 years.
So you're just a young associate?
Not even 2 years.
Yeah, you're trying to make it, right? Your bank account probably doesn't have that much in it at the time.
I have student debt. I'm getting up at 6 a.m. to go play hockey with the partners on Sundays. I am doing everything I can to succeed. And, my script was, if you get invited to an opportunity, you take it. So I said, hey, playing golf on a Monday morning, I'm all over it.
Yeah,
right?
yeah.
So I get out there and we're having fun and the beers aren't flowing yet. But I hit this shot and I'm like, oh my God, that felt good. And the ball bounced twice. And this is comical. These guys that were there supervising the hole-in-one are sitting in lawn chairs. They don't even know what to do when I hit the shot because nobody knew what happened to the ball. It just disappeared, right? So I'm thinking I overclubbed myself, right? It's in the evergreens behind the hole because this hole in the backdrop, there's evergreens that kind of form a semicircle behind the green. So out comes Pat Wren, the CEO of St. John, and he's signaling with his arm. And I'm like, what is going on? So next,
you think you hit somebody or something?
Yeah. So next thing I know, the 25, 26-year-old is taking control of the situation. I'm telling these guys what they need to do. Number one, I'm playing a Titleist #1 all black HVC. Okay. I think the ball is somewhere near the cup. All right. You guys got to jump on the back of the cart. Let's go. They're like, no, we're going to drive because we have to make sure that we're doing this the right way. So I let these guys drive the cart. They actually drive the cart onto the green. And I'm like, guys, you can't drive a cart on the green.
It's like contaminating the crime scene.
You got to back up. So we all take steps towards the hole, and they look down in the cup, and my ball's in the cup.
You made a hole-in-one.
I made a hole-in-one.
And you won the prize.
I had never hit a hole-in-one before.
In your life.
I had no idea what to expect.
Yeah.
So next thing I know, carts are coming from all parts of the golf course because this is spreading like wildfire. Some young kid just hit a hole-in-one. There's a beautiful coupe,
Lexus.
a $50,000 car sitting by the tee-off box. I think this kid might have won something.
And so how happy are you at this time? Like, John, are you just on cloud nine?
I don't know what to do, but the biggest satisfaction of that whole situation, I've never in my life written a 1 on a scorecard. I couldn't believe how good that felt to write a 1.
Yeah.
So zoom forward. I don't want to get too deep into the weeds here, but this is crazy. Things start happening.
Everybody's high-fiving you and stuff.
Everyone's high-fiving me. I've got more golf to play.
Yeah.
2 holes later, there's another Lexus on another hole. I pick up the same club, and I literally almost hit a second hole-in-one.
Oh, my God.
It was insane. So we finished the round, and I've got a 1, I've got a 2, I've got some, it was fun. We had a great day. So as is customary with these big golf outings involving clients, there were obviously people scattered all over the golf course, but take 18 times 4. That's how many golfers you have, right? 18 holes, foursome each hole. There must have been 5,000 people in the reception area, way more than golfers after the event. And of course, my dad was a sales manager who sold medical equipment. St. John was one of his big customers. So Sister Senforia sees my name tag, hears that I had hit a hole-in-one. She comes over immediately and says, I know your father very well. Congratulations. I hear congratulations are in order. We had fun. We're buying drinks, having a great time. But all of a sudden the spotlight comes on me at the dinner table. They call me up to the stage and
in front of all these people.
In front of all these people saying, congratulations. We'd like to, congratulate you on hitting a hole-in-one and winning a prize. They wouldn't tell me what it was at the time. So then I get up to the stage. I'm escorted up by, whomever, Lexus people, and they hand the microphone and they say, well, you won a car.
Oh my gosh. You won the Lexus?
I won the Lexus. And they said, well, so what are you going to do with the new car? I said, well, that's easy. I'm going to give it to my mother.
No way.
The whole crowd goes crazy. So I get into work the next day.
And you're probably on top of the world.
I'm on top of the world. I'm calling my parents. I called my mom and dad, and at the time they had a landline, so they put it on speakerphone. And my dad had maybe 1 hole-in-one. He said, well, what'd you win? Some clubs? I said, better. He said, better? I said, oh, yeah, Dad, better. I said, I won better than golf clubs. He said, did you win like a membership to a golf course? I said, no, Dad, I actually want a car. He's like, what kind of a car? A Chevette? I said, no, Dad, not a Chevette. He says, well, I hope it was a Buick. No, Dad, it's not an American car. He's like, well, you can't accept it if it's not an American car. I said, Dad, I'm accepting the car. I don't know what it is yet.
Yeah.
So I go into work the next day, and Jerry Kenny, who you may know.
Yeah,
Jerry,
great guy.
Jerry at the time was the firm managing partner. He was a goalie. We'd play hockey together every Sunday. So he came in, he says, hey, I got some news. And I said, Jerry, what's the news? And he says, well, did you get a copy of the firm handbook? I said, what firm handbook? I never got a copy of a handbook. He's like, well, you gotta know that there's a partner in the firm who won a diamond necklace at a door prize event, and he had to give the diamond necklace back to the firm.
Oh, come on.
I said, are you kidding me?
Come on.
You think I'm giving this vehicle back to the firm? I said, oh, no. This was not a door prize or a lottery. This was a skill shot. And I said, you know what, Jerry? You do what you got to do, and I'm going to do what I got to do.
No way. Good for you, dude.
So I call up Lexus and find out that there was hole-in-one insurance. Who knew? And that was really the start of my insurance career. Was in 1992, September 28th, when I hit the hole-in-one. I learned that there's insurance on everything.
Everything. So a hole-in-one insurance was, because it was so uncommon for someone to hit a hole-in-one, they didn't expect anyone to win. But in the event they did, the insurance company actually stepped in and paid for the car?
Correct. So I called finally somebody from Torrance, California, a suburb of LA. They were with Lexus Champions of Charity. And I kind of took a little bit of a leap of faith. I got this very nice person on the phone. I'll never forget her name. Tizzy Riegas. And I said, Tizzy, I'm in a tizzy because I don't know what to do. I think the firm is trying to take this vehicle from me. And she says, Mr. Eads, let me stop you. You're the beneficiary of a hole-in-one policy. Unless you execute some agreement signing your rights away, you will never forfeit this vehicle.
John, that's pretty ballsy. You're a young second-year lawyer. Second-year lawyers, I mean, you are a foot soldier for, especially when you're at a larger firm, right? And are, you're trying to start your career out. There's a lot of politics. You don't want to piss people off. You're just trying to make it. You got debt. You don't want to do anything. And so you said, you know what? Screw it.
Screw it. I'm taking a chance on myself. And
that's amazing.
My whole goal was I made a promise to my mother, and I was not going to give that promise up. So I got another job at O'Connor, DeGrazia, and Tam, and I started there, and probably the best career move I've ever made in my life.
And did you get the car?
So interesting. The word on the street was I left because Kitsch enforced its policy. Okay? The car was delivered to Jimmy Bryan Lexus. Russ Epstein and I and my dad took a picture in front of the vehicle. I wrapped the vehicle in a red bow, and I drove it from Orlando to my parents' home in Volusia County, Ormond by the Sea, delivered it to my mom on Christmas Eve.
Good for you.
They built anything I wanted and boated it over. So I got a LC 400 black jade, tan leather, 6 CD changer. It was tripped out, right? So my mom was beside herself. And I said, Mom, you deserve this, but for you and your focus on education, all four of us, 2 lawyers, a doctor, a very successful salesperson, we would have never been where we are, and we would have never achieved what we achieved. And it was incredible. It was the best feeling in the world. After putting 19 years of education front and center for me, my parents deserve that. And my mom could not have been more elated that her son decided to give her the vehicle.
And probably ultimately a good career move, although it's hard to see that at the time, right? Like when you leave a job, or especially under circumstances like this, which is, by the way, that's a cheap move, man. A big firm trying to take a car from a second-year associate, but
yeah, there's always a silver lining, right?
Yeah,
and it made me become more aware of life. It made me become aware of insurance, and that really catapulted my my career in a lot of ways. I wanted to be in the courtroom, and it allowed me within a year of getting to O'Connor and Grazia and Tam as a third-year lawyer, get my first trial under my belt. Yeah, and I did a great case for Beaumont and that led to many, many more cases from Beaumont, and also allowed me at age 40 to get into a BOTA because I had so many different trials under my belt.
Yeah.
By the time I hit, age 40.
How many trials do you think you've done in your career?
Oh God, I've really lost count.
A lot.
I've done quite a few trials.
Yeah.
I've had just an incredible run of trials where sometimes it's better to be lucky than good.
Yeah.
Oakland County jurors. I think maybe I've lost one case in Oakland County in my career. The toughest cases that I had were in Wayne County.
Yeah.
And that's obviously a tough place for defendants to try cases, but I've had so much success there as well.
Yeah, I love Wayne County.
Of course you do.
Yeah, we want to be in Wayne. I call it the best county for what we do generally, depending on the case. Different cases can play in different places. You know what I mean? Like there's certain interesting things, but we recently had a case together.
We did. And so it's funny that you talk about the mediator who had a conversation with you, because he asked me the same question.
No way.
And I said, well, it's pretty simple. The two best trial lawyers I've seen in my career, one for sure in person is Jeffrey Feiger, without a doubt. And he said, well, yeah, but I mean now. And it's Venn, it's Jim Harrington, and Jon Marko. Those are the three that all defense lawyers get nervous about. It's like a cautious elation, because it's going to be a big case.
Yeah.
And that you have to sharpen all your tools, because you're going to have to do your best. You're going to have to leave it all out there to get the best result you can. But you also know there's going to be a trial at the end of this, unless somehow, some way, you can come up with something unique as a value driver toward our side to get you guys and your clients to take a look at realistic value on cases.
Yeah.
So the case that we just got, it's funny because a lot of times in my career, I'm asked to take over cases from other lawyers. The case we just had was exactly the same situation, where a very large big box company contacted me a month before trial and said, hey, we've got a case that we need your help on.
Month before trial, which is hard.
It is
and
hard.
To give, see, this is interesting, because I feel the same way about what you just said about me, about you. And in this case, I had taken the case over, so our listeners understand. So I was contacted by an attorney who said, look, I think this case might go to trial. I need you to take it over. And you were not involved in the case at that time. So I entered my appearance with the court, and I started to try to, get up to speed, so to speak, on a case that's been going on for many years. And then once I did that, suddenly the defense attorney who represented the big box company said, we better get somebody. And they went and got you. So we both kind of subbed in. It was like subbing in the first line right before the Super Bowl or something.
It was incredible. And the amount of energy and focus that takes, it's not all about me. It's not all about you. It's
right.
about our offices coming together and putting all of our collective efforts in to digesting a case. The hardest part is just getting the file from the prior lawyer.
Yeah, and organizing it.
And organizing it.
I mean, don't you think it's harder as a trial lawyer to come in at right before a trial and try to get things in order than if just to have it from day one? I mean, it's like studying for a final exam with like a week to learn the materials. You know what I mean?
It's a great point. But what we do and what we did going through high school, challenging high schools, going through very challenging academic institutions in undergrad and also law school, is we know how to crunch and we know how to get ready for the big time, right? And so in a way, it helps you uber focus on what the critical issues are, and
right.
You don't get caught up in the weeds.
Not get in the weeds. Yeah, I noticed you use that term, Jerry Spence. You know who Jerry Spence is?
I do. I know Jerry Spence as well.
Great, legendary lawyer. Like when I remember working on some trials, and Jerry would always say, like, you're in the weeds. Get out of the weeds. Right. It's like you can't get, a lot of lawyers get like overwhelmed with all this minutia, some of which can be important, but some of which is not, and nobody cares about, and it just bogs you down,
Absolutely. In fact, before we came in, I was talking to your significant, and we were laughing about just like focus in how do you get focused on what you think is going to be most important to the jury? And when you're in an expert dep, we did an expert dep of a very talented orthopedic surgeon over at Beaumont.
Yeah.
And that's, I had tried probably 20 or 30 cases for Beaumont. So I have a high regard for their staff physicians. And this particular physician was hell-bent on helping your client.
Yes, he was a very, and I had never met this expert before. So, and just so that our listeners know, before you go to trial, sometimes doctors can't be there live to testify. So in this particular case, the orthopedic surgeon was not able because he had surgeries at the hospital. So the court allows us to basically video record and do a cross-examination of the doctor. And then we play that video to the jury at trial, just like the doctor was there, right?
Yeah, and you did an incredible job with the technology. The blow-ups, the assistive biomechanical type of pictures that you sent to allow the doctor to demonstrate to lay people who might be, accountants, they might be factory workers, exactly what happened to this particular woman's body. It was incredibly persuasive.
But that doctor he was great. That was the first time I met him, and I was like, man, this guy is being mean to John Eads.
He was definitely not on my team.
Yeah.
And so under those circumstances, there's no way you're going to mano beat him. He's way smarter than me. But you have to hit a couple of singles, and maybe you'll get a double.
Yeah.
If you swing for the fences, it's not going to
never
go
going to
well.
happen,
It's
right?
never
Unless you have the
gonna
smoking gun or
go
something,
well. And when you're getting an evaluation on a case that you're trying to get ready for trial, it was funny because I got called, hey, John, I got to talk to you about this case. Can you mock this for us? I had to get on a call with probably 8 to 10 people and play you.
You had to play me.
I had to play you. And I convinced them to give me enough money that I felt would get the case settled because of me playing you. Okay? And that's a clever lawyer. You need to convince your client about me, and I need to convince my clients about you. And what carried the day in that case were two things. One, I convinced them that the prior counsel under-evaluated the case.
Which makes it very, very hard to get things done, especially on your side, right? So, because explain to people who maybe don't know this. So when you have a case, do you have to tell the insurance company like what you think the case is worth?
Well, this particular client had a very large self-insured retention that was not funded by insurance.
So what that means is they had to pay out of their own pocket.
Correct.
Right?
So they had to pay out of corporate coffers. And anybody knows, I remember back in the day, I worked for a firm where the 4 named partners had credit cards. Well, one of the partners used to use the credit card to buy Starbucks, newspapers, and the lead partner finally cut them off. Once you have to spend your own money, that will really move you to be a lot more frugal and a lot more sensible about how you spend money. Companies that have to spend their own money that isn't funded by insurance are very, very, very frugal about how they want to spend their money. They want to spend smart money, okay? And it's our job as defense lawyers to convince clients to pay smart money on cases, okay? And how are we able to do that? Like anything else, you look for data. You look for recent results. I cited your Grant versus auto owners case that was a $7.9 million verdict in the same courthouse. And I talked to them about the case, and I went through the verdict form with them where the jury gave $100,000 a year for the rest of this young man's life. And I told them that there are risks. Here are the risks. Here's the verdict form, okay? Now, in that case was a little bit different because it was a named insurance company defendant.
Right.
And it sounds like there were some other issues going on, whereas my client was a big box client that evaluated cases probably differently. And so it was my job to get on I call it the Hollywood Squares, 16 people on a Zoom call and convince them of what I perceived to be the upper and lower values of that particular case.
Yeah.
And we got some luck. We had a great result in motions in limine. I didn't argue those. My partner did, and she did a phenomenal job.
Good
and
lawyer.
I think that was a value driver that helped us talk to our respective clients.
Because then I had to go back and tell my clients, look, this didn't go as well as I had expected or hoped for, and we were able to get it done. But I think the big thing here was look at all the work that it took to get this done on both sides and the good lawyering. And two good lawyers came together, did good lawyering, fought like hell for their clients, and came to a result that probably neither side was totally thrilled with, but which was probably the right result.
Exactly.
And so, the problem is when if you didn't have you on the case or you didn't have me on the case, I don't think that would have happened. Who knows what would have happened?
Who knows?
You know what I mean?
But probably, I just settled 3 big cases recently with one of your competitor firms, the Figer firm. And I kind of jokingly sent a text message saying, hey, where's my fruit basket, right?
Yeah.
And the other lawyer responded. He's like, hey, I just got to tell you, I'm not blowing smoke. You did an excellent job for your clients. If I had these cases with other lawyers, these would have been
never
much
settled.
different numbers, and we probably would have gone to trial. And I think it's great to have mutual respect from your side of the aisle, my side of the aisle. I know when I represent personal injury attorneys who get sued for legal malpractice, they know who I am. And it's fun because we partner together, and they love to talk about strategy, about deposing the underlying doctor on proximate cause issues and causation issues. And they see how my brain operates when I'm representing them when they've been sued for legal malpractice for making a mistake in a case, or the perception is they made a mistake.
Right.
And so that also hones my skills as a trial attorney, because I get to look into how you folks on your side of the aisle evaluate cases, work up cases, what experts you choose. And then when I'm put in a position to have to defend what you did as a plaintiff attorney, that creates a lot of really important lessons for me as a defense lawyer.
And you have kind of the information, right?
Exactly. So, but look, it's not all about settlement. I mean, we try a lot of cases.
So let's talk. We're on Cases Gone Wild. So tell us about some of your craziest cases. I know you told me that you had a crazy mistrial case where you had to try the same case multiple times.
Yeah. So I've had 2 cases in my career that were long cases, like 3-week trials where, we're halfway through, and for whatever reason, the judge says, I'm declaring a mistrial because somebody made a mistake during the trial.
Which means you have to start all over, right?
You got to start all over again.
Whole new thing.
Spend all that money again that you already spent, The couple of cases that I had, one was involving 2 different doctors. So one of them had left the state. He was now at Shands in Florida, and it was an emergency medicine case. And he had to come all the way back up a second time. And just the psychology that goes into that and keeping them invested in the case is so difficult. But sometimes it's not through the fault of the lawyers that a mistrial gets declared.
Yeah, like somebody says something they're not supposed to say or something.
In this particular case, out in Oakland County, we had a visiting judge. He was from mid-Michigan, and he wasn't really used to some of the stuff that goes on where we are.
Yeah.
In Oakland, Macomb, and Wayne counties, where things can get a little crazy.
Yeah.
It's not like in mid-Michigan where there's not a whole lot going on, right? Maybe you see a couple of crazy things, but we see them all the time.
Yeah.
So this particular case, it was a husband and a wife who lost their son. And there was an allegation that he wasn't properly diagnosed in the ER. He went home, and then he died that night after being in the ER literally hours earlier. But what we were able to figure out through the toxicology is that he had all these different types of medications, many of which reduce lung function when you take them together. And so the Oakland County Medical Examiner's Office, in my opinion, made a mistake on evaluating the toxicology, claimed it didn't play a role. I hired a board-certified emergency medicine and toxicology expert who testified at trial live that, oh my God, the amount of medications and the interactivity of all the medications that this young man took, he was a quadriplegic, they suppressed his breathing ability and he died during the night.
But how'd that help your doctor if your doctor gave him the medications? Or did your doctor not?
Our doctor did not. They were his own medications that he had at home.
Okay.
So he basically over-medicated himself because he was in pain.
Okay, got it.
And
so what caused the mistrial?
The mistrial was really strange. So I was actually, it started off really funny because the judge liked my sense of humor. I had a very prominent lawyer I was trying the case against who would come in every day with a big Starbucks cup, and then he would empty the Starbucks cup into a regular styrofoam cup that didn't have any markings on it.
Yeah, smart lawyer.
Right. And then,
so he didn't look too bougie or whatever for the jury. Yeah.
So he would disappear and go to the bathroom, and then what I would do is get the Starbucks cup out of the trash can and pour it back in. and so we were on a break, and the judge said, "Mr. Eads, let's look at the tape on this objection you made." And then it's actually, he zoomed it too forward, and it caught me pulling the cup out of the trash can
and pouring the coffee in the
so
Starbucks cup.
So we all got a big laugh out of that, right? But anyway, this particular lawyer's clients were interesting. The wife literally looked like something out of a wax museum character. She had this face that just never made any reaction.
This is the plaintiff,
the mother of
the deceased.
Yeah, and,
okay.
And they were very into the case. I mean, the Mister was super excitable. He was always making gestures, and so anyway, one day after trial, we're halfway in. They followed the judge out to his car.
Who followed the judge out?
The plaintiffs. And so
the clients, the people suing,
the people suing followed the judge out to his car. And so we didn't know this.
And what did they say?
The judge never said, but he said that
that's a big freaking no-no.
They made threatening comments toward him because they didn't like his evidentiary rulings. Okay, so what ends up happening is these poor folks are so distraught about A, the death of their son, and B, having to broadcast their personal business in the courtroom, and then C, getting bad advice. They felt from the judge in terms of rulings. So they followed him out to his car. The judge comes in the next morning and tells us that he feels threatened by the plaintiffs, and he decides to recuse himself from the case and declare a mistrial.
In the middle of the case.
In the middle of the case.
And so all that work, you guys had picked a jury, you guys did opening statements, you guys put on evidence. It's all wasted.
The two doctors were making no money. They were sitting in the courtroom for over a week. One of them came all the way up from Florida. The other one was, had a very prominent position at a local hospital, and they were beside themselves. So we had to go and try the case all over again, and we won the second time around, thank God. But it was just such a something I'd never experienced in my life, and it was so difficult to keep your composure, to keep your clients invested in the case. To tell them that out of principle, we have to see this through.
Yeah. And do it all over again.
And do it all over again. And that happened again, recently in front of Judge Groner with another lawyer. But and that's another great example of a plaintiff attorney and defense attorney working together. I had a case with a very good lawyer, and we went to trial for also another week. It was Thanksgiving week. And on Wednesday, the judge declares a mistrial. The Wednesday before the Thursday Thanksgiving break.
For what? Why?
There was a challenge to my cross-examination of a doctor and on mechanism of injury and what caused death. And basically, long story short, my client had a truck without a trailer, and it mechanically broke down on the freeway, and it was parked on the freeway during rush hour in the lanes of travel on a freeway. And the plaintiff was a plumber who had a bunch of stuff in the back of his truck. And a lot of trucks have those fences between the passenger compartment and also the back end so that stuff doesn't come forward.
Yeah.
Well,
like a pipe doesn't flow through.
He didn't have one of those fences, and he had all these loose pipes and everything in the back. And what happened was he ended up rear-ending the truck.
And then don't tell me the pipes came through.
The pipes came through the back, and so I was
and killed him.
I was arguing that had he properly fastened the pipes wouldn't have come through and killed him. And the judge the plaintiff attorney made a motion to for mistrial because I didn't disclose that that's what I was going to be, asking
Like
the
your
doctor
theory
on
of the
cross
case?
and my
Okay.
theory of the case, and so he got frustrated and he asked for a mistrial, and the judge gave him a mistrial, so he had to retry the case again. So in that case, there was only $1 million in coverage, and so what I did, because I felt like I had a good jury the first time. The second time, I didn't feel like I had a great jury. So we entered into what's called a high-low agreement.
Oh, yeah.
So the low was 250 and the high was $1 million. Well, the second time when I had to retry the case didn't work out as well as the first time for the hospital. And I got smoked for over $3 million. But being who I am, I thought about the fact that I didn't like the jury, and I was able to leverage a high-low agreement, and I saved my client quite a bit of hassle and harm because I put what I call a collar on the top.
Yeah, so for the people who don't know, a high-low agreement is, in this case, there was only $1 million of insurance money, right?
Correct.
So you go to the plaintiff's attorney, who could be like me or whatever, and say, let's agree on basically like parameters, a high and a low. So in this case, 1 million was the high. Is that what happened?
Correct.
And then 250 was the low. So that means if the person wins $100 million, for example, it gets reduced to the high, which is $1 million.
Correct. And
or if they lose, the person loses, like the jury says 0, then it goes to the low.
the 250.
Right.
So it guaranteed them some money, and then it also, smartly on the top side, it didn't expose my clients to anything more than the insurance money.
Yeah.
And my client, the owner of the company, was dying of cancer, and he was in the courtroom every day with a trash can next to him.
Oh my God.
And because he would get sick quite a bit. But again, he felt strongly about this case, and he felt like it wasn't his fault that the truck mechanically stalled in the middle of the freeway because they had rented the vehicle from a leasing company that also had the contract to service it. Nobody could ever figure out exactly why this vehicle mechanically failed.
You hear about this, like vehicles in the highway. There's a lot of those cases, John. A lot of people die or get hurt, like a truck, and at night, because you're just driving along and you don't expect there to be a vehicle there. But there's a lot of cases like that. I've had them all over the state.
Yeah, and some of these trucks, if you see them out there, sometimes they don't have all the reflective
Stuff.
equipment on the back of them if there's not a trailer attached to it. So sometimes they're difficult to see until you come right up on them. And so it was a challenging case, but that was the second one that we had to try twice. I mean, those cases are always challenging cases, especially in Wayne County.
Yeah.
Especially when you have a person who passed away and a grieving family. And so those take a special kind of attention and a special kind of commitment as a defense lawyer to be able to A, put yourself in a position to try them, and then B, win them. They're very difficult to win.
Yeah, for sure. What I heard you had some crazy case where somebody jumped out of a car.
Oh my gosh, yeah. So earlier in my career, this is when I started and catapulted myself into the insurance world. So I was getting these cases from some big insurance companies, and I was starting to try a lot of cases. And so, there's some hot lawyers out here now. I think you'll probably be talking to a couple of them that are defense lawyers who go on these runs, right? Like Caitlin Clark hits, 10 threes in a row. Well, there's some defense lawyers out there and plaintiff lawyers, who win and win and win and win. And so your name gets out there. And so companies start to gravitate towards giving you an opportunity to get their business. And so this one company from New York had a local office in East Lansing. They hired me, and they were sending me, like, the fax machine was ringing. You know? And it was, I was feeling pretty good because I was a partner. I had just gotten my name on the door at this particular firm. And so business was coming in, and I was literally in trial twice a month. And I was trying cases. This one was a challenge. This young man jumped out of a car that was doing 25. He was out partying all day out in the Ann Arbor area with his wife. And they got into an argument. He had had all kinds of drinks. And interestingly, in the medical records, they identified what he had drank all day long, and it was a lot.
So he was like wasted?
He was wasted. His wife had to work the next day. They lived in the apartment complex where he worked as a maintenance person, so they were living rent free. But she had to work. She had a job outside of the apartment complex. I can't remember exactly what she did, but they're driving home. They get in an argument. She turns up the radio, and he says, "I'm out of here," and jumps out of the car
While it's moving
at 35 miles an hour.
Oh my God.
So I get the call about this case.
Did he die or?
He did not die. He had a significant and serious, at age 24, lifelong brain injury.
Oh my God.
He became a completely different person. It was like Jekyll and Hyde.
Yeah.
So the person who got the case was the author of the No Fault book. And talk about being intimidated. I was intimidated. And it was
the plaintiff's attorney who represented the injured guy?
Correct. So one of the top personal injury attorneys who happened to be in Ann Arbor filed this case in Ann Arbor. And I didn't get the judge I thought I was going to get. I got a different judge. And
well, what was the theory of the case, though? If the dude got drunk and just jumped out of a car,
well, as you know, in Michigan,
it was for no fault?
2019,
okay.
There was lifetime medical. And so the family was concerned because the medical bills for this young man were about $20,000 to $30,000 a month. So he was initially treated here, and then they moved him to Florida, to the Florida Institute of Neurological Rehabilitation.
Okay. So this was a case. It wasn't against a person. It was against his insurance company to try to get medical bills paid.
Correct.
Okay.
And interestingly, they already had incurred a ton of medical expenses, but the real trick for them was to get medical expenses covered for the rest of his life.
Right.
He was not somebody who could really function in life without full-time supervision. His brain injury was so bad that he had to be sent to Florida to have hour-to-hour supervision.
And those costs go astronomical, man.
I mean, you're talking $20,000 to $30,000 a month for the rest of his life. He's in his 20s.
Right.
So the key in the case always comes down to the little things, like the movie. The little things were the documentation by the paramedics at the scene, the history taken by the people at the hospital, the social worker who interviewed the wife, and also anyone else who could talk about what he was doing that day and what happened to him. And so this area of the law is really, really obscure because there's an exclusion in the policies for acts that occur due to intentional acts.
And so, in other words, like I just had a case that was, we had some problems with where this guy in Detroit was drinking some malt beverages on his porch. He got into a fight with another guy. That guy got into a church van and ran him over with the church van on the front lawn. And our guy was really messed up, but we had problems because the attorney for the insurance company said, no, we don't have to cover this because this guy did it on purpose. He tried to basically kill you. He tried to murder your client.
Right.
And so because of that, insurance doesn't kick in. Is that the same type of thing?
It was very similar, but what we were able to do, as good lawyers do, is we were able to work out a jury instruction that we gave to the jury as follows. First of all, you don't have to intend both your act and your injuries, okay? But if you intend your act here, jumping out of a vehicle 35, and you do that volitionally, you do that by choice, then anything that occurs because of your intentional act is barred from coverage. The insurance company doesn't have to pay for it. The trick here, was his intoxication. And there's a case that we found, I think it's Schultz versus auto owners or auto owners versus Schultz, that says that alcoholism or intoxication does not mitigate or vitiate your intent. So
in other words, you can't say I was wasted as an excuse for why you did something.
Exactly.
I think they have the same thing with like murder. Like if you murder somebody, like you can't say, well, I wouldn't have murdered him sober.
Yeah, I had diminished capacity
Yeah,
or something
I
like
was
that,
wasted,
right?
you know?
And that was the epiphany that I had during my closing argument. Is the jury of 7 in Ann Arbor, when I did my closing argument, I said, ladies and gentlemen, this is a tragic case. I feel for the family. This is a lifelong injury. When we went down to take his deposition,
Who's that?
Mr. Wales, the gentleman who was brain injured, okay, and this is a Court of Appeals opinion, so I'm not speaking out of turn. He threw his computer at us when we were taking his deposition because he thought we were coming to take him home. He was that far down the path, and so I felt personally horrible about the family, but and the challenges financially for the family. However, out of principle, our foreperson was the HR person for a big company who understood human resources and managing employees and things like that, and ultimately,
big mistake. Side note: big mistake for plaintiff's attorney to leave the head of HR on the jury.
And in a 5-2 decision, the jury went the insurance company's way, and this is what resonated with the jury. They were told by me in closing arguments that they had to treat this individual as if he was sober. What sober person would jump out of a vehicle moving 35 miles per hour, and not intend to get the very injuries that this young man sustained? And that carried the day.
Right.
It simplified the case and put them into a position that they could make the right call according to the law.
Still a tough case from a defense perspective.
Very difficult case. I mean,
like, I'm going to trial in a couple of weeks on a no-fault case. The insurance company doesn't want to pay. I mean, I find that especially nowadays, people have had bad experiences with their insurance companies.
Right.
And most people, not all, are like, just the insurance company just should pay. And it's very rare because in most cases, you don't get to tell the jury that they have insurance. For example, in that big box case that we just had, the title of the case is, X person, Mrs. Smith or whatever, versus X corporation. The jury doesn't get to be told X corporation has all this insurance that's going to pay for some or all of the case, which can make a difference.
Correct.
I still think those cases are hard, defending those insurance companies who don't want to pay for, especially in a case like this, where the guy needs the medical benefits. Don't you find those are hard? I'm not saying morally hard. I'm saying hard to defend from an insurance company perspective.
Absolutely. Absolutely. In fact, in that particular case I was talking about with the gentleman who jumped out of the car, the head of claims called me and said, had you not won that case, I would have lost my job.
Are you serious?
I'm totally serious.
Why would he have lost his job?
Because A, I was a younger attorney, and B, the exposure in that case was over $40 million. Because the plaintiff attorney smartly asked for a declaratory ruling from the jury.
Into the future
under that Manley versus Dolly case.
Yeah.
And so it was dangerous. But fortunately, they had the confidence to let me do it. And I was able to deliver what they felt was a good result.
Yeah, those are hard when you're younger, though.
They are.
And you don't have the reputation, because if you win, like, you're the greatest thing on earth and everybody was so smart to trust you and everything else. But when you're young and you don't have that, if you lose, it's like, you can be blamed. Oh, it was his fault. Or, it's good to be at our stage of the career where now I think, look, everybody loses cases, right? And if we lose a case, then I don't think it's reflective on us as a whole. But
no, but also you have to be a risk taker as a trial attorney.
You have to be. It's risky business.
You would not be sitting in this room doing this podcast, Mr. Marko, unless you took risks early in your career on cases that were tough cases.
Yeah.
That you could have settled.
Yeah. And
right?
And we, some of them are. It was a lot tougher in the beginning. Let's just put it that way. You know what I mean?
You have to earn your stripes.
You have to earn them.
For those of us that try cases regularly, it's tough because it's a balance, because you have a certain amount of ego involved.
Yeah.
Because you want to win, but then you have to remember that you have to do what's best for your clients.
Right.
And ultimately, at the end of the day, it's all about your client.
That's right. That's right.
But another fun case we had was this is a crazy case. Sometimes, even though you do everything right, you still don't get what you want, and you still might not get the result you want. I remember a case I had in Wayne County. One of the first cases I tried in Wayne County, I had the blue ribbon set of experts. You could not get better experts. The case was set up. It was a liability case.
What type of case was it?
So it was a trucking case, and it was at 6 Mile and Merriman. And I was representing the company that delivers Mrs. Fields frozen cookie dough.
Okay.
You couldn't ask for a better client, right? And he was heading on a rainy day through a light, and the light turned yellow, and he's in that situation where, do I stay or do I go?
Yeah.
Like the song, right? He decides to go, and he makes it all the way through the intersection, but there was someone coming the opposite direction perpendicular to him. So he's going east and west. The other car is going north and south. And the vehicle hits the very back tires of the trailer. So the entire vehicle, all 80 feet, make it all the way through, except this car runs into the back of the tires. Anyway, this case was litigated, very, 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 very tough litigated case. And we went into trial in Detroit. And the demand was $15 million. It was a very substantial case. This is over 25 years ago.
A lot of money.
A lot of money on the line. And nobody from any of the companies that hired me showed up for trial ever.
Why not?
Great question. So I'm having to give them, before morning updates, and then after I'm done, exhausted, and having to get ready for the next day, I'm on the phone an hour after because they chose not to show up. And that's a defense lawyer's worst nightmare, is when clients don't show up to see the nuances that go on every day. It wasn't a virtual courtroom.
Right.
It wasn't on TV. You couldn't watch it on YouTube back in those days. So,
and it's a lot easier when you're detached, sitting in an office, corner office somewhere, getting phone calls to not be involved. It's like in the military, it's a lot easier to drop a bomb from, 100 miles away than it is to, shoot a guy in the trenches. Right.
Right. So I'm nerved up this whole trial because it's a big trial. There's a lot of exposure. I'm using an accident reconstructionist who's never testified. I found this person who's now very, very prolific around the country as a testifier. I found him and put him up. But
this was his first trial?
This is his first trial.
So it's always a little nervous because, experts, their first time around, it's like they can be taken advantage of, and
Yeah, he was a little self-deprecating. He was he gave a little bit more than I want him to give on cross, right? But other doctors who you use testified live, and so it was amazing because we probably had 12 experts. And it was a big long case. 3-week trial. But two important things in the case. One, jury selection. How do you pick a jury? Who do you look for? Who's going to benefit your client? Who's going to benefit the plaintiff's client? How do you figure out who to use? How do you figure out who's going to be fair, right? In this particular case, I ran out of peremptory challenges, which are challenges that you can strike somebody for. You don't necessarily have to state a this
almost any reason but race and gender, I think.
Exactly. And back in the day, this particular era, judges were taking a very heightened interest in who you were striking. And so I had to be very careful about who I was striking and why. I had to have palpable reasons. And so in this particular case, there was a individual who was a plaintiff's personal injury attorney who does what you do.
Yeah.
Who was left in the box.
So they were going to be picked for the jury?
They were going to be picked for the jury, and I exercised a challenge for cause because I was able to tease out from this person that she had used the same experts that the plaintiff attorney was using in this case.
All right, hold on. So in your jury, so you're picking a jury, and one of the jurors is a plaintiff's attorney like me who represents injured people.
Correct.
And that plaintiff's attorney had also hired the same experts that were going to testify in your case?
Correct.
On behalf of the injured person?
Correct.
So she
clearly had a bias.
Yeah, I mean, I don't know.
And clearly was familiar with the same injuries and the same fact patterns. The judge would not strike her.
What? That's crazy.
It was insane. I've never seen anything like it in my career, and I'd picked a lot of juries to that point. Be that as it may, we went along, and this case went on for 3 weeks, and we fought tooth and nail for 3 weeks. The never made a settlement offer because we were convinced that the jury would find that the plaintiff was more than 50% at fault, which would bar his claim.
lose. They
would lose, right? So the jury gets instructed, and the jury...
So this lady's on the jury?
This lady's not only on the jury, she becomes the foreperson.
Oh, no.
So the jury's deliberating all day on a Thursday. We go home. They literally deliberated for 8 hours, could not reach a verdict.
And my view is generally, although not always, the longer the jury is out on a civil case, the better it is for the plaintiff or the injured party.
No question about it. And fortunately, they hadn't asked for a calculator yet, right? But the jury for the second day is out all day long. We don't get any questions. We have no idea what they're debating. But obviously, they must have been debating percentage of fault.
Right.
Who was more at fault than the other? The jury finally comes back late Friday, and 4 or 5 of the jurors look at me, and they just shake their head before anything was said.
Oh, and so how many jurors were there total?
There were 8 total.
Yeah.
So we agreed that if 6 out of 8 reached a verdict, then that would be the verdict.
Yeah.
So I'm concerned at this point, right?
Oh, yeah.
So the jury comes back. They find that the defendant was negligent. They also find that the plaintiff was negligent.
So both sides shared in some fault.
Right. So the $1 million question was,
how much?
How much? So we get all the way down to the percentage of fault, and it was 55% defendant, 45% plaintiff. And the total verdict was $797,000, which I was thrilled with.
That's not a big verdict because it gets cut down then.
It was $15 million in a demand, but I was troubled with the 55-45. So I went and interviewed each one of the jurors who would talk to me, and ultimately they all pointed at the foreperson, and they said it's her fault. We were on your side, 51% plaintiff, 49% you, Eads, your clients, because we felt that the plaintiff was more at fault than the defendant because he was there to be seen.
But that one person made a difference.
That one person told us that if we do that, he's going to get no money.
Yeah.
It was because of her unique education in being a plaintiff attorney. She brought that to the jury room, and that carried the day for the plaintiff.
So that's an interesting. So they've done all these studies. In my opinion, the kind of strength of the juror or the outspokenness and leadership abilities of the juror is often one of the most important things that I use in jury selection. So in other words, if I have a very, very strong juror who is very pro my side, that juror could be more important than like 3 weak jurors who are pro defense side.
That's your alpha.
I'll take the
alpha.
one. I'll take the
Right.
one to your 3 because my one, if my one is strong and is a leader, is the alpha, so to speak. And that's a perfect example about it. And I had a case in Macomb County in front of Judge Servito against the Department of Corrections where we went through jury selection, and one of the jurors was a plaintiff's attorney from Florida who had same as us, who had sued people. And in that same thing, he became the foreman, and he became our strongest advocate on that case.
How did the defense lawyer let that happen?
I don't know. You got to ask them.
Wow.
So, and we got a pretty good verdict. Never as much as I had hoped for, but it was pretty good. It was a multi-million-dollar verdict, so that was good. But that goes to show the strength of the person in there. But also, I just tried a recent case in Wayne County when we talk about getting a fair jury. And I'm not going to say this judge. I think 99% of the judges in Wayne County, excellent, awesome people. This is like the one judge who I think is just a horrible judge down there. And it's a case against DTE Energy, okay? Big corporation. So I'm picking a jury, and I asked this guy, I'm like, do you have any ties? And he said, no, there's no reason I can't be fair. But then it slips out, I'm friends with the CEO of DT Energy. I said, oh, you're friends with the CEO of DT Energy? He's like, yeah. I'm like, well, are you going to see him soon? He's like, yeah, we're going to go golfing together in like a couple months. I'm his caddy.
Interesting.
And I'm like, well, sir, don't you think it might be a little difficult for you? Because I'm going to be asking for many millions of dollars,
Right.
to then have to go golfing with your buddy. And he's going to ask you, why did you do this to me, to our company or to me? The judge left him on. I don't know how they can do that type of stuff.
Yeah, it's a similar situation with the plaintiff attorney in our case that we talked about. Why would you leave that person on? It didn't make any sense.
That's ridiculous.
Yeah.
And I think a lot of times judges figure, well, you can use your strike, you can use it, and let's just get this going. But that's not right.
No, it's not right. That should be a situation where you get a challenge for cause, so you don't have to use your preemptory because you only get 3.
Yeah, you only get 3.
Yeah,
and we got to have a fair jury for both sides.
You do.
I can live with a fair jury for both sides. I always tell the jury, like, look, would I love a jury full of plaintiffs' attorneys? Of course I would. But the system is designed, give us a jury that can be fair to both sides.
Absolutely. You want a jury that's fair and impartial and that can see both sides because there's always 2 sides of a story, right?
Yeah. And you can't go golfing with your buddy 2 months later and he's going to be like, why would you do that to me, Bill, or whatever your name is,
Yeah, you don't want to put yourself as a juror in that position either.
Exactly. That's not good. I wouldn't want to be in that position. I wouldn't want to be on a jury where my buddy, like if John Eads, you were getting sued, I wouldn't want to go to court and have to do that because you're not going to come on my podcast if I give a multi-million-dollar verdict against John Eads. All right, I'm getting the time thing, but let's talk about one last thing. So we were talking, and tell me, have you ever, because when you get ready for trial, okay, like it's hectic, I'm running out the door, your mind is focused on one and one thing only, John, and that is the case, right?
Right.
And so I've had some cases. I was trying a case down in Wayne County, and I remember the lead attorney was Bob Giroux. You know Bob?
Oh, yeah. I know Bob well. Excellent lawyer.
Bob, and I was a young lawyer, and Bob ran out the door and didn't have a belt. So his pants were hanging down. It didn't look right? But this shit happens. And so I took off my belt. I was a young lawyer. I said, here you go, and help make the wardrobe. I had a case where in Ingham County where I had a very important hearing. And I had a sports-related injury. I had surgery, but I wanted to go back to work. I probably went back a little sooner than I should.
Right.
I was a little foggy. I had to take some medicine. And I ran out the door and forgot my suit jacket. So I drive all the way to Ingham County. I get out, and it was, that judge over there. It was Judge Kennedy, I think, at the time.
Yeah.
And I go into the back of my car to grab my suit jacket, and I'm like, oh, shit, right? So there's no time to go back to Detroit. Worst feeling in the world because it makes you look like a fool. You feel like a fool.
Right.
And especially when you're younger.
Right.
Like now I could laugh about it a little more, but when you're younger, you're just worried about anything. Even now I'd say shit, but then it was big. So, I had to go in and I'm waiting for them to call the case, and I checked in, and the judge never calls the case because he's looking out the courtroom, and he's like, well, it looks like on this case, we still don't have the plaintiff's attorney because I didn't look like a lawyer. I didn't have my suit jacket.
Right.
I'm like, no, Judge, I'm sorry, and, I had to argue. I felt foolish, but have you ever had a, looking back, it's funny, but at the time you're like, oh shit type wardrobe malfunction.
The exact same thing happened to me. I'm in that long trial that I was telling you about with the Mrs. Fields cookie dough and the plaintiff attorney who's on the jury. And I'm in the zone. I'm in my office early. I have to be down in court in Detroit at 9, but I'm in Farmington Hills and I'm getting some stuff ready. I'm getting organized, and I leave without my sport coat.
Yeah. Because just so people know, we don't wear our sport coats inside all day generally. I mean, unless it's cold or something. You take that thing off, you throw it over a chair or a coat hook.
Right. So I get down to court, and by the way, this particular judge was making me come into court before the other lawyers in the morning and explain to him why I don't have anybody there representing the company who's in the courtroom.
So was this on that trial
He was on that trial.
Okay.
And he's making me stay after and explain to him why nobody's there.
So he's already pissed.
He's been pissed, beyond pissed. He's also pissed because his trial's taking so long.
Yeah.
He's also mad at me because I had a witness who was supposed to be there right after lunch who wasn't there, and the jury was in the box, and he did this to embarrass me. The jury was in the box. He's on the bench. The court reporter's there. All the lawyers are there. Everyone's in the courtroom, but I have no witness, and he's just tapping his fingers on the bench.
In front of the jury. There's nothing worse than that.
And I keep waiting to hear the bell from the elevator because it was dead silence. You could hear a pin drop. So I'm trying to figure out a way to break the ice with this judge. And of course, what happens? I forget my darn sport coat. So I'm about 6'2", and the judge is about 5'9". So I get down to court early, and I say, "Hey, Judge, can I see you for a minute?" And he's like, "We have our normal discussion here, right? Where's your clients? Are they coming this week?" And I said, "Well, can I borrow your sport coat?" He literally cracked up. He's like, "It's never going to fit you." So I ended up going the whole morning with this sport coat. I look like T-Rex.
Yeah. That's like we had the Chris Farley, like fat man in a little coat. Remember that?
That broke the ice.
Yeah.
That broke the ice.
Yeah.
And he says, "You got a lot of guts asking me to wear my sport coat. You're lucky I wear a robe."
Yeah,
so,
yeah.
But I mean, what are you going to do?
What do you do? And I think that is too, if you have a malfunction like that, whether it's a wardrobe malfunction, something else, is just be authentic and like own it. And,
exactly.
Because what else can you do?
There's nothing else you can do. And also doing a lot of extra things like we do, pro bono things, taking cases that people can't afford, and being active in the bar associations and demonstrating your commitment to other things, not just, being a lawyer, but also being a person. And a lot of the folks in Wayne County know us because we do have a commitment to pro bono work.
Yeah, right.
And we do take cases like that on, and
we're at
judges,
the events.
Judges want to see that. They want to see involvement. They want to see your firm sponsor events. They want to see you being involved in the legal community and not just being a lawyer,
right,
but also being a person. I think a lot of times that carries a lot of weight with judges too. Judges will give you the benefit of the doubt when something like that happens. You forget a sport coat, or you speak out of turn, or you get emotional about an issue with opposing counsel and you interrupt opposing counsel.
Yeah.
And I don't do that so much anymore,
Right. But none of us are perfect.
We're not.
And there's always going to be things that don't go exactly how we had planned them to go. And you just got to roll with the punches. And
you got to roll with the punches, and you got to use your support system around you, because we get nervous. I mean, what we do is high pressure, high stakes. And so, I used to practice my opening statements to my kids, and you practice your opening statements to your partners.
Yeah.
And because it's very, very comforting when you can get constructive criticism from people when it's not a client, it's somebody who's impartial.
Right.
And that's so important in what we do as trial lawyers, because a lot of times we don't really connect in a way we want to connect. And somebody like a juror who's going to be on the jury giving you pointers about how you can connect better, we're not perfect.
Yeah, right.
And that can help you carry the day with some issues.
Absolutely.
Like, how can I connect with this judge who does not like me?
Yeah, that's always the hardest thing. All right, so we're going to end on this. I got one last question. Where's the Lexus now?
The Lexus is gone. It's probably in Saudi Arabia. I put 325,000 miles on that. But
no way. Quick
vignette. When I got my job after the 6-year statute of limitations ran, my mom called me and said, "Come pick up this car." So I drove straight to the DMV, and I'm trying to come up with a clever license plate. And so I want to get a personalized plate. So it just comes to me, epiphany. So my license plate to this day is still HOLNWON. Hole in one.
Well, good. John, thanks for coming on
John,
the show,
it was great
man.
being. Thanks for having us.
Yeah, thanks for being a great lawyer and a great dude.
Thanks for being an outstanding mentor to a lot of great young lawyers, and thanks for making us and keeping us honest on the defense side.
Thanks, buddy.
All right. Have a good one, Johnny.
Everybody, thanks for listening to another great, crazy, wild episode of Cases Gone Wild, brought to you by Jon Marko and Marko Law. If you or someone you know needs help please don't hesitate to contact us. That's markolaw.com, M-A-R-K-O law.com, or give us a call, 833-MARKO-LAW, M-A-R-K-O Law. We'll see you in 2 weeks for another Cases Gone Wild.